There you go. So now let's just, I think by the time you get done going over like the rules and stuff, I think we'll get a few more people. So,
Hey, good morning, everybody. I hope everybody isn't melting right at this moment. Can't believe how hot it is.
Yes.
We're from Stewart Title. My name's Jill Chandler. I'm the division sales manager for Stewart Title here in Utah. And we're glad to be back again. We enjoy doing classes for Presidio. So this morning, I'm going to start off with a little 24th of July quiz. Ready? And one of the rules is you have to participate. The state has said people have to participate and interact in order to get credit. So here we go. Which famous outdoorsman did Brigham Young get a few tips from? Kit Carson, William Clark, Jim Bridger, or Daniel Boone? Any guesses? Come on, you can guess.
William Clark.
Darren?
Number one.
Number one, Kit Carson. Anybody else? Come on, get a guess, because nobody's guessed it right yet. All right, I'm just going to give you this one, but next time you guys have to participate. Jim Bridger. Okay. What was the number one killer along the plains? What did people die from?
Diseases.
It starts with a C. I don't have a on this shirt. I don't have a.
Colorado.
What don't I have? Cholera. There you go. There you go. Okay. What percentage of people under the age of 20 died? 10%, 25%, 45%, 65%.
45.
Under the age of 20. How much?
40.
45?
45.
Bingo. You're right. 45% were under the age of 20. So that's now this last one. Oh no, it's not the last, it's second to last. I don't know if you'll get this one. Which of these unusual foods did the Mormon settlers eat? Succotash, quiche, oysters.
The first one, whatever the first one is.
Succotash. That sounds like what it would be, but it's not.
Oysters.
No, that leaves us with one. Quiche. They said they would just put together everything, and they always had eggs and make quiches, which that I was surprised. Okay, the last one. What is the common label for a street down which pioneers walked following mob oppression, forced them to leave the city and the city that they had built? Number one, Street of Tears, Trail of Hope, Pioneer Trail, or Trail of Sorrow?
Trail of Hope.
Yes, you're so smart. You've got them all today. Nice job. So there's just a little fun about Pioneer Days. We, on the 4th of July, we always spend it with our grandchildren up in our cabin, and we always do a 4th of July quiz, and it's always fun to see what they do. So I thought I'd do a little one for you today. Okay, so for those of you who haven't been to our classes before, I want to tell you that we have offices from North Ogden down to Spanish Fork across the whole Wasatch Front. So we're available to do closings in any of those offices. Most all of our escrow officers will travel and can do travel. So that's one thing. Then another thing I wanted to tell you was a product that we offer. If your broker has your title company hold your earnest money, we have an app that you can download, and it's called Zochem. Have anybody heard of Zochem before?
No.
Okay, so Zochems, you can take a picture of the front and the back of your check, like you make deposits, some people do to the bank, and that will send it to the title company into the account. And then when they receive it, then notifications will go out to all parties connected to that contract. So anyway, if you're interested in that, that's something that I can show you that we can do. Okay, we're going to move ahead. Today's class is going to be contracts. Contracts of basics. Our speaker is Mark Chandler. He is our in-house attorney for Stewart Title. He's taught business law at Weber State. He's been in the business for about 30 years. He's really, really smart and handsome, and he's my husband. So those are the things you should know. I should have put the husband first because that's the most important one. So anyway, Mark, here comes Mark. And I forgot the important thing. So the other thing the state wants us to do is make sure you're paying attention and that you're staying to the class the whole entire time. So as the class goes, Mark will hold up letters and you will need to write these letters down. And at the end of the class, and I'll put it in again, I have put my email address in the chat, and just email me the letters. If you can't get, email me your name, your license number, and the letters. And then I will take that and I will bank that roster this very day if you can do that for us. Hey, Mark.
Hi. Hello. How is everybody? How was that warm-up act? That was a pretty good warm-up act, right?
Yeah, it's good.
Yeah, I got some letters here. I'll be holding up some letters, and so pay attention and ask questions. We're going to talk a lot about the Repc today. So if you've got a Repc in front of you, that'd be great. Did you send them a Repc with the outline?
I don't know.
Oh. All right. Well, dig up a Repc someplace. We're gonna refer to it quite a bit today. So, well, happy 4th of July and 24th. Hope everybody had a good, safe one. I forget some of the questions that we had in our 4th of July quiz. Anybody know who the oldest signer of the Declaration of Independence was?
No.
Oh, you know this. How do you not know this? Benjamin Franklin. He was 70. Yeah, he was the oldest signer. So I didn't really expect you to know that. Okay, well, has anybody ever had been involved in litigation, lawsuit over a real estate transaction, a sell?
No.
Or the contract, the Repc?
No.
Yeah, it doesn't happen very often. And when it does, it's usually for issues post-closing. So people take residence, and then they find out that something doesn't work, or something was not disclosed that should have been disclosed, the roof leaks, or the heating system doesn't work. So most litigation is post-closing. You don't very often see lawsuits enforcing the Repc. There seems to be sort of a conception that the Repc is not binding. It's not a binding contract. And people breach the contract all the time. Sellers decide not to sell, buyers decide not to buy. And so, that's earnest money is usually there to kind of help remedy the damage that people have. And so usually people just resort to the earnest money. Litigation is costly and time consuming. And so you don't see it very often. But it does happen, and I've been involved in some lawsuits where performance was forced, and I'll talk about that a little bit toward the end of the class. But it's called specific performance. But usually, there's really 5 issues, that come up in a contract dispute, and that's kind of what how this outline is organized. So it's essentially 5 questions, that get asked in a contract dispute. The first question is, well, was there actually a contract, right? Is there offer, acceptance, and consideration? And I'll talk about those, and the difference between just a promise to do something and a promise that actually results in a binding contract. Second question is there a reason why the contract might not be enforceable? It could be against public policy. It could have been a contract made by a minor, which is unenforceable. Or it could be a legality issue. Could be a contract for an illegal purpose. And if it's a contract for an illegal purpose, a court won't enforce it. So gambling contracts, for instance, in Utah are not enforceable because we don't allow that. And we'll talk about some kind of contracts that are against public policy and for various reasons. Then the third question is, are there defenses? Are there defenses against enforcement? Was there a mistake? Is there undue influence? Is there some sort of fraud or duress or something like that that would be a defense against enforcement of the contract? And then another question is, well, who has the enforceable rights? Enforceable rights has to do with assignments of contracts, and we're going to talk about assignments of contracts. And we'll talk a little about wholesaling and how wholesalers assign their contracts. I don't know if you guys know that term or what wholesalers are and what they do, but we're going to talk a little bit about assignments. And then another question is, are the performances actually ripe? Are they actually ripe under the contract? Meaning, are there conditions or contingencies that have not been met? And so you're really familiar, with contingencies and conditions because you have things like appraisal conditions and financing conditions and the sale of an existing residence and those things. Those are conditions. And there could be conditions on both sides. Both sellers and buyers could have conditions. And if those conditions are not met, then maybe the performance that is due is not yet enforceable. So we're going to talk about three different kinds of conditions: conditions precedent, consequent, and subsequent. And then the last question is a question of damages. So if you do have a lawsuit and there's been a breach of a contract, then the question is, well, what do we do about it? Is it a money damage, and it usually is money damages. Contracts are typically resolved through the payment of money and judgment is ordered. But with real estate contracts, there is such a thing as specific performance. So in certain circumstances, a court will force a party to comply with the terms of the contract of the Repc. And that's useful. I think that's kind of useful to know that a buyer has a remedy against the seller for specific performance. So let's start at the very start, and that's on contract formation. On contract formation, and you've probably heard this term before: offer, acceptance, and consideration. That's considered the trilogy of contract formation. You need to have an offer, an acceptance, and then it has to be supported by consideration. We're going to talk about each one of those. But let me start by reminding everybody of something really important in contract law, and that is this. Under Utah law and the law of most states, this is a common law concept, right? This came from English common law, and we imported it to the United States, and that's what's called the statute of frauds. The statute of frauds, not frogs, frauds. Statute of frauds. And what the statute of frauds says is that certain contracts have to be in writing to be enforceable. Certain contracts are not enforceable unless they are in writing. Now, a lot of people think, well, every contract has to be in writing, right? But it doesn't. I mean, you have oral contracts and implied contracts. You know, if you went into a grocery store this morning, or you went to Starbucks and bought coffee, you entered into a contract with Starbucks. You don't think of it in terms of being a contract, but it is a contract. And yet you didn't write anything down, nor did they, and you didn't really negotiate, you know, the purchase of your coffee. You just went in and saw an offer, essentially an offer, and you accepted an offer and you paid for it. They gave you your coffee and you paid for it. Well, that was all a contract, and nothing was ever put in writing. So under the statute of frauds, there are 5 types of contracts that have to be in writing to be enforceable. And the mnemonic device I use is my leg. So M stands for marriage. So marriage contracts have to be in writing. So postnuptial, antenuptial agreements, or actual promises to marry one another, those are not enforceable unless they're in writing. The Y stands for year, contracts that cannot be performed within a year by their terms. And I'm gonna leave L as my big finish. E stands for the sale of goods by a dealer in excess of $500. So I could make an offer with you for the sale of my vehicle. And that could be an oral agreement. If I'm a dealer, however, you know, I regularly sell cars. That's part of my inventory. And I've got to sell in excess of a transaction in excess of $500. That has to be in writing. And then the G stands for guarantor. So a guarantor is a person who agrees to assume the debt of another person. So like a cosigner. So if you co-signed with a child or a family member on a loan, you're becoming a guarantor. They are the borrower, right? They're the borrower. But if you are guaranteeing their performance on that contract, then you're a guarantor. That has to be in writing as well. So big finish. What is the L? Anybody? It's our business. What do we do? What are we in the business of? Land, right? Land. So L stands for land. So any contract dealing with property has to be in writing. So for the buy, the sell, the purchase, the lease, those contracts have to be in writing. So often you will see verbal agreements for, say, the lease of a property or an easement. So you've got a client. Sorry about that. So you've got a client who buys a piece of property out in a rural area, and then they look out their window one day, and somebody's driving a herd of sheep or cattle across the land. And so you say, "Hey, what are you doing on my property?" And the person driving the cattle says, "Well, I've been doing this for years. I was told that I could run my sheep on this property or my cattle across this property, or I could drive across this property to go hunting or fishing." Well, what you're talking about is an easement, and that is unenforceable unless it's in writing. And there are certain circumstances, there are exceptions to every rule. Some circumstances where an easement might be established without a writing, through prescription, what's called prescriptive use, which is continual use over a long period of time. But all of our contracts are in writing, all the addendum, the contract and the addendum and everything else. So, okay, does anybody have any? That's just kind of a starter when it comes to contract law. And then it's obviously good practice if you're entering into any kind of a transaction, good practice to get it in writing in case you do have to litigate it and you have some issues. So, okay, so offer, acceptance, and consideration. And there's kind of a technical, each one of these is got kind of a technical definition of what they are. So an offer, for instance, is something that has three components to it. So it's kind of common sense, if I offer to buy I think we all understand what it means to make an offer to purchase a house. But technically, an offer is something that is definite. It's definite. It's communicated. And it's manifest a serious intent to be bound by the terms of the offer. So if I make an offer in jest or in anger, it doesn't really constitute an offer because I've made it in jest. So, I'm driving around town with Darren in my car breaks down, and I'd say, this car's a piece of crap. I'd sell it to you for $100. And Darren pulls $100 out of his pocket, hands it to me, and says, "Hey, it's a deal. I accept your offer." Well, I wasn't serious, right? I was just making a statement in anger that I didn't really manifest an intent to be held to that offer. Definite just means that it's clear what the terms are. So you don't make an offer on a Repc that doesn't have the parties identified in the transaction, or the purchase price that you're offering, or the date of closing, or an identification of the property that you're buying. So a real estate contract has got to have certain terms with it. So that's what that means. Now an acceptance has got some technical requirements as well. It's communicated. It's also got to be definite, and definiteness with an acceptance means something a little bit different. And it means that it has to be identical. It has to be identical to the offer. Meaning, if my offer contains all of these terms, right? My acceptance has to be identical to the terms of the offer, or it's not an acceptance. So if I offer to buy your house, right? And I've got all the terms of my offer. And one of my terms is that I want certain things included in it. So, got all these terms, and one of them is I have some items that I want included in the transaction. And you accept all of these terms, but not that one. So you say, "Hey, I accept your offer, but I will not throw in the items that you want included in the sale." That is not an acceptance. What is it? It is something, but it's not an acceptance. Does anybody know what it is?
Rejection.
It's a rejection, but it's also a counter offer. It's a counter offer. So whenever you have a counter offer, that counter offer is a rejection of, without saying that it's a rejection, it is a rejection of the offer because it's not accepted in its entirety. So the acceptance has to be identical to the offer, or else it's a counter offer. And what is the effect of a counteroffer on an original offer? So if I say, let's say under this scenario that I come back and I counter, right? I counter that I won't throw in these items that you want added. And I say, well, then I'm not going to perform, right? Or we don't have a deal. I'm not going to buy your property without those items included. And so you come back and say, okay, I've changed my mind. I will include those items. Well, if I don't want to take that offer, right? I don't have to, because you rejected my original offer. It goes away, right? It's done. It's over with. And unless I'm willing to, be bound by the terms of my original offer, I don't have to be, because my offer was rejected. And so it's got to be identical. And then it also has to be unequivocal. It has to be unequivocal, meaning it's got to be clear. It's got to be clear that the offeree, essentially, who is accepting the offer, it's clear that they intend to be bound by the acceptance. And at that point, you have a contract. Now, your Repc has some really important language in it, and it has to do with acceptance, it has to do with acceptance. And it gives a two-part formula. There's a two-part formula for what constitutes an acceptance in the Repc. And so anybody want to take a stab at the first one? What does the Repc say constitutes an acceptance?
Responding by a deadline, signing it, autograph.
Yeah, so it's got to be signed, right? Got to be signed.
Communicated.
And it's got to be signed, and it's got to be communicated. Now, Jill, what do you mean? What do you think the Repc means by communication?
I think a verbal or an email.
This is kind of
communication.
This is kind of a tricky question. What the Repc says has to be communicated is not the acceptance. It's not the acceptance that's communicated. It's the writing that's communicated. It's the signing that has to be communicated. And so if you have not communicated the signing prior to the expiration of the offer has expired and it's not been accepted. So, for instance, I've made an offer to buy your property for $500,000, and my offer is only good through a certain period of time. And so that this Repc says that time is of the essence. And so if I say that my offer is good until Friday at 5:00 p.m., then if that acceptance has not been made of my offer prior to that time, then the offer expires and it's gone. So let's say that I have your offer in front of me and I've accepted it, I've signed it, but I don't communicate that signature until 5:05. And that communication could be a telephone call, right? We've signed the contract, or it could be an email, or it could be a delivery or a fax or something like that. If I don't communicate that I have signed prior to 5:00, if I do it at 5:05, the I don't have to be bound by the terms of my original offer, because my offer expired because you didn't communicate the signing prior to the expiration of the offer. And so you think that this is kind of a weird little technical wrinkle, but it does come up. At least once a year, I see a scenario under which there is a question of whether or not there is a binding contract. There's been an acceptance of an offer, and in these days when you've got so many competing offers, you want to make sure that you don't get stuck in a scenario where you're giving, say, a seller of a property an easy out to take a better offer because you haven't communicated properly the way that the Repc requires, right? So you can imagine that in a market like this, that it would be important that all of your I's are dotted and all of your T's are crossed. So just bear that in mind, that the Repc says you don't have an acceptance unless it's signed and the signing is communicated. Okay, does anybody have any experience with that? Anybody? Okay, well, hey, I'm going to do a letter, make sure everybody's awake. Everybody see that? That is a floating Q. That is the letter Q. That is a Q, right? Yeah, that's Q. I've taught several classes this week and I'm a little burned out. So I think this is a Q, right? Yeah. Okay. Consideration. Does anybody have any questions on any of that stuff? Consideration. You probably have heard the term before. Anybody want to take a stab at describing what consideration for a contract is?
The earnest money.
Pardon me?
Be there the earnest money for consideration.
Well, you would never do this because you are smart people. But you could have a contract where there was no earnest money. Right?
I guess I've seen it where they did a promissory note, like a promissory note.
Yeah, that you have seen that before?
Oh, it was like 10 years ago. It was weird.
Yeah. You don't have to have earnest money. It's standard customary practice to do it. And I think that you would be guilty of malpractice if you didn't write a contract that included earnest money. But earnest money is something else. Earnest money is not the consideration. Consideration is something of value that's given to by both parties. And in a real estate transaction, I would say that the consideration is the offer of money for title. So the buyer's bringing in money and the seller's bringing in title to the property. That's the consideration. So anything of value can be consideration. So if a person is already legally or contractually obligated to do something, but they make an agreement to do it anyway, there's no consideration for that transaction because they aren't giving up something of value that they weren't already obligated to give up. So it gets kind of technical, and it's rare, very rare, I would think, that you would see a transaction that failed because a judge would say, hey, there's no consideration for this thing. Consideration can be love and affection. I mean, it can be a promise not to, drink or smoke. Somebody says, hey, I'll give you $500 if you don't have a drink today. Well, okay. If I have the legal right to drink, what's the drinking age now? It's 21, right?
Yes.
If I were 19 years old and somebody said, I'll give you $500 if you don't drink, and I agree to that, that's not consideration because I'm already legally obligated not to drink. And so that's probably not going to be an enforceable contract. But if I'm over 21 and I have the legal right to do it and I agree not to, then that's consideration. So, but rarely do you see consideration as an issue. So let's spend a little time on earnest money. If earnest money is not consideration, what is it? And so let me ask you, let me give you a hypothetical, and maybe this has happened to you before. So let's say that you have a contract that requires earnest money. So the buyer's got to bring in 5,000 earnest money within, what is it, 4 days? What does the Repc say? 4 days for earnest money?
Yes.
Yeah.
4 days.
So, yeah. So what if the earnest money, what if the buyer sends a check and the check bounces? And so it's now day 5 or it's now day 6 and there's no earnest money. Most people would say that contract is void or voidable. Most people think that makes the contract void or voidable because the earnest money has failed. That is not the case. And so there are several provisions in the Repc where it says specifically that one party or the other party can void the contract at their election. But this isn't one of them. So there is nothing in the Repc that says that if the earnest money fails or isn't tendered, that it makes the contract void. There isn't anything in the contract that allows that, in the Repc that allows that. I mean, it's a problem, you know, clearly it's a problem. If I've got a buyer who can't come up with the earnest money, doesn't it kind of make you wonder how he or she is going to actually get the money to buy the property? You know, I would call it maybe an anticipatory breach at best. And so it deserves a discussion. Well, why don't we just cancel this contract? If you can't come up with the earnest money, I want to cancel the contract and do a cancellation of the contract. But don't presume that the contract is void, right? Because if you do, and you put that property under contract with another buyer, you could have an issue. You maybe have got 2 buyers for the same property, and you don't want to get there. So if you've got a problem with the earnest money, make it clear that the contract, the Repc then ought to be canceled and get both parties to sign a cancellation of the Repc. So does anybody have any other issues or questions? So what is earnest money? So if earnest money is not consideration that can lead to a voiding of the contract, what is it? Well, it's about 5 or 6 different things. I kind of alluded to I think the most important part of earnest money, which is its use in the event of a breach. And so it's what's called liquidated damages. Liquidated damages. So let me kind of tell you what I mean by liquidated damages. And the Repc never says liquidated damages. There is a reference to what the purpose of liquidated damages is in the financing section. But liquidated damages means damages that are easily ascertained or are defined by the terms of the Repc. So let me give you a scenario, and maybe you guys have had this happen to you before. If I'm selling my property and at the last minute, the buyer decides not to buy the property, what could possibly be my damages, or how am I damaged by the buyer not performing as they've agreed to under the contract? Does that question make sense? So put yourself in the place of a seller, and you have a buyer at the last minute say, I'm not going to buy. And now the seller has got some damages that he might want to sue for. What would those damages be? Well, the loss of the sale, for starters, But is there anything else?
Maybe they had earnest money on a property they were purchasing and they can't perform on that.
Right. So, right, they maybe have some other obligations that they are not now able to perform. They might have moved. They might have hired movers and storage companies. Now they've got to put all of their property in storage. There are opportunity costs. You know, there might have been 5 other offers that they could have taken that they've now passed up on. And some of those might have been better offers for more money. There are all kinds of things that could constitute the damage for a seller. And so that's difficult to ascertain. And you could do the same exercise with a buyer. So if the seller, sure, you got a buyer and you've got a seller who at the last minute decides not to sell, well, buyers got damages too. They might have quit a job, they might have moved, now they've got to find some place to live. You know, they've got all kinds of there's all kinds of repercussions to them for the seller having breached the contract. Well, that's what, and that's difficult to ascertain as well. That's what earnest money does. Earnest money is an agreement. It's an agreement between the parties that if one of them breaches, that, say that $10,000 in earnest money will be measured, that will be the damages. And so if it's the buyer that breaches, then the seller gets to keep the $10,000 to offset their damages. And if they agree to do that, right? So if they agree to keep the money, they can't sue because they've already agreed that by keeping the earnest money, I'm being made whole because of the breach of the buyer. And what the buyer gets is the earnest money back and then a like sum. So if it's $10,000, the seller is breached, then the buyer gets the earnest money back, and then the seller has to come up with another 10, has to match it. And that's the buyer's damages. So that's I think a really important part of earnest money. And then, you know, it changes the status of the property. It makes it under contract. And so, you know, you stop marketing it, you stop soliciting offers for it and taking offers for it. And, you know, it's good faith. It's a good faith, gesture of good faith. And then obviously it's also a down payment, right? It gets credited to the buyer against their purchase obligation. And so it's a down payment. You know, I've been in this business a long time. And I remember when earnest money was almost always like $500 or $1,000. Well, $500 or $1,000 is not appropriate earnest money, right? Because it's really meaningless. So I really like now that we're doing 5 and 10 and 15 and 20,000 in earnest money because it's more meaningful and it's a closer approximation of a remedy, you know, in the event of a breach by one of the parties. So has anybody, how do you guys use your earnest money? You know, there's a couple of provisions in the Repc that are, you know, you have the main earnest money portion up at the top of the Repc, but then you've also got a provision in the financing section where a certain amount of the earnest money can go hard. It goes hard. It's non-refundable. And presumably that is a way for a seller to weigh the relative merits of multiple offers. And so if I've got a buyer that is willing to allow a certain amount of their earnest money to be non-refundable, then, you know, in theory, that is a better offer and one that I'm going to take, you know, as opposed to the other offers. So who uses that and how have you used it?
Remember, they have to participate.
Somebody's got to have used it, right? Come on, people. Are you there? I've had participation from Jill and Darren. Somebody else weigh in. Who's out there? Can you guys hear me? Has nobody ever used that?
Never used non-refundable earnest money yet, so.
Oh, okay. Well, thank you.
I always make sure we have at least a 48-hour due diligence deadline before it becomes non-refundable, you know? I just hate to have earnest money accepted up front when you don't know if seller has clear title and things like that, so.
Yeah, well, and even that, even if you did use that provision, that money is still refundable prior to the due diligence deadline. And so after the due diligence deadline, then it does go hard. But if you do find something, if you have agreed that some of your earnest money will be non-refundable, and then your due diligence discloses something about the property that's terrible, then you don't lose your earnest money.
Well, but if it's after the due diligence deadline, you do though, right? Because
Yeah.
it's not refundable. Yeah. And then I guess the other issue is with non-refundable earnest money is I guess with FHA addendum loans is if the appraisal doesn't come in, the buyer cannot lose their earnest money in any way, shape, or form. So the FHA loan cost would supersede any agent writing a non-refundable earnest money. Would that be correct?
Yeah, I think that would probably be a good analysis of it. And I haven't spent a lot of time with it, but do you use that new appraisal addendum?
Yeah, there's the appraisal adjustment addendum, but what's going on in the industry is people are bidding up these prices, and originally they'd be a conventional loan, and then after we go into contract, they'll send in an addendum that says even they have the appraisal adjustment, they'll send a $10,000 non-refundable earnest money, but then afterwards there's like, oh, we need to get an FHA loan, and then once they did the appraisal, as long as the appraisal value comes under, it almost like it makes the earnest money becomes refundable, because for any reason, if the property does not appraise, if they're getting FHA loan, they will not lose their earnest money.
Yeah, and I actually think that I think I might have misspoken on that section. Let's see. Yeah, it's not the due diligence deadline that triggers that allows the buyer to get the earnest money back. Is the financing and appraisal deadline. And so, yes, if you're past your financing and appraisal deadline, my understanding is if you've made that earnest money non-refundable, it's not refundable. And so
even if the FHA clause saying and a buyer cannot lose earnest money in event of any appraisal issues.
Well, are you talking about the FHA addendum?
Yeah, the FHA addendum basically states that for any reason, if the property does not appraise, the buyer cannot lose any earnest money for any reason at all.
Okay, well, that's good.
That's what's the kind of the loophole that we're seeing that people can maybe bail out. I mean, that's not the buyer's agent intent to bail out, but it does give a way out in case somehow the loan does fail. They can use that as an excuse to say, hey, look, it's an FHA loan. We can't lose earnest money, as much as they try to say our earnest money is not refundable. I mean, it's just kind of gray area. I mean, the agents go at the like I have a client buying my listing right now. They're doing that, but in the back of my head, I'm all like, hey, look, if this loan does fail for whatever reason, you know, they could pull out this FHA addendum clause that say the buyer can't lose any earnest money in the transaction.
Yeah. So, let me ask you this. Well, and then there is a second earnest money provision you know, that nobody ever uses. I mean, you see it in Park City on these highly appreciated properties, but nobody ever uses that second earnest money. You know, I had an interesting conversation with a broker in a class about the scenario where a buyer represents that it's a cash, their offer is cash, and then it turns out not to be cash, but rather it's a hard money loan that the borrower is getting. So I think that's kind of creepy, frankly. I don't know if you guys have seen that or not. Is cash really a deal maker in your experience? Because there seems to be a lot of talk that cash offers are the only offers that are being accepted these days. That's obviously not true. That's hyperbole. But I've heard that it's a little bit of a misconception that there are a lot of cash offers. There are some cash offers, but
Yeah,
there are not as many cash offers as sort of the myth would have it. What's been your experience?
in my experience, we're like, even if I got offers in cash, they're generally not as high as someone that's getting a loan, because it's almost like the mental mindset is like, if you're making an offer and you're not cash, you got to pay a little bit more of a premium versus the cash offers. And the cash offers I get, even though they're over list price, but they're not substantially over list price. That's why the conventional borrowers have to do an appraisal gap. They're willing to pay a certain amount above appraisal to make their offer just as good as cash. And obviously with the conventional offer, even if a cash offer, they want to do a due diligence and close like 10, 14 days. That's why even if you're conventional and you and your lender are on a team, and once you go under contract and you order the appraisal and inspection right away, to beat that 10-day inspection deadline as of a cash offer, then you're all good. Because a lot of people selling their house, they don't need to close in 14 days. That's kind of rush for them to close in 14 days. So right. As long as you can do the appraisal and inspection and be able to communicate with the listing agent, it increases your chance, even though you're getting a loan, to beat out those cash offers, you know. And I don't think you're violating any fair housing law if you're just choosing cash or no cash, and you just want to do a owner occupant borrow a favor versus an investor or a cash buyer or whatever, you know. So
yeah. So what about that? What about that scenario where I think that maybe my offer is stronger because I make it a cash offer, and it turns out that it's not really a cash offer. I'm getting a hard money loan.
Yeah, that's why their inspection deadlines are stretched out, like, or their closing deadline is stretched out, or their financing, their cash offer with the financing and appraisal deadline is stretched out. So even if they're getting hard money, I guess if you put up a bunch of earnest money, if you gave me 10 grand earnest money and you're a hard money, but it becomes all non-refundable 10 days after due diligence and there's no finance deadline, I don't care that you're getting hard money. You got 10,000 hard after 10 days. If your hard money lender doesn't give you your loan, I'll take the 10 grand.
Yeah, it's kind of problematic for title companies because, you know, if it turns out that it's not a cash transaction, then we've got to prepare for that. You know, there are notes that have got to be prepared, and there are trust deeds and you know, different kinds of problems that ought to have been disclosed to the title company at the very start if there is going to be a lender involved in it. So.
And then if people is putting a lot of earnest money up, and they're in, let's say they're putting their earnest money into Stewart title, and let's say it's non-refundable, but the buyer doesn't sign to release it. Let's just say they violate it and earnest money needs to be released on the contract, but the earnest money is, let's say, installed with Stewart title. You need signatures from both the seller and buyer to release the earnest money, and they can just be like, buyer can just be like, no, we're not signing. If you sign, I want half my earnest money back or something. So that's why now we're not wanting earnest money to be installed with any title company, is because buyer will also use that as leverage just to get some earnest money back, you know, to be able to have their signature to get earnest money released from a title company.
That's a very good point. I mean, there was some discussion a few years ago about prohibiting the practice of title companies holding earnest money. And I was all for that. I mean, you know, we don't like to hold the earnest money just because we get into those scenarios, we get into those conflicts where we're being asked to make a decision about release of the earnest money when there's not consensus by both the buyer and the seller for the release of the money. And then we become, you know, a referee, and we get it from both sides, people that think that they're entitled to the earnest money, and we don't like to get into that situation. So Darren is right. You know, if we hold your earnest money, we're going to call the shots. It's our rules. We're not parties to the Repc, and so we aren't bound by anything that the Repc might say or might not say. And so we have our own set of rules, and that rule is generally, if there's not consensus on the release of the earnest money, we're just going to continue to hold it. And if we have to, we'll interplead it, you know, give it to the court to hold in what's called an interpleader action. And, you know, that's just a waste of money, because it costs money to do that. And that's just a waste of money to have to do that. So, yeah, we don't like holding it. There was a scam a little while ago on earnest money where buyers would come in and they would, you know, they put 20,000 down, earnest money down, and then they would trick the seller. I guess you can't really call it tricking the seller if the seller's an adult and, you know, knows how to read the contract. But I give you 20,000 and I make a really short due diligence deadline, like a due diligence deadline for 2 or 3 days. And then what I'm counting on is that the due diligence cannot be performed because the title company cannot get a title report to the buyer in that time frame. And so, you know, if it takes 3 or 4 days for the title report to go to the buyer, then these scammers would then say, well, seller, you have breached the contract, right? You have breached the contract because you have not provided me with the due diligence documents as required by the Repc, and I want my 20,000 back, and I'm demanding 20,000 more for damages, and I will sue you to get it. Well, that's just a scam. That's not a breach. I don't think that's a breach of the contract. There are consequences maybe for due diligence, but that's not a breach of the contract. But there were some brokers who felt that they had to go to their E&O to pay that you know, blood money so that they didn't get sued. And so, you know, if anybody tries to pull that, I'd stand up to those guys all day long. So, well, let's move on. Thanks, Darren. Thanks for your input. Let's move on. And I'm going to do another letter. Letter is F. That question of public policy, you know, or some other defense of the contract, there are really just 3 main things to remember. You know, there are certain people who lack capacity to contract. Minors cannot contract. Incapacitateds and intoxicateds. So, you know, and there's certain rules for each one of those. So you would never have an offer from a 16-year-old, for instance, or a 17-year-old. Now, there are exceptions to that. If the 17-year-old is married, then they are considered an adult and they can contract. Or if they have been emancipated by the court, then they can contract. And an emancipation is a court order that said, this kid's on his own now. And so he's to be treated as an adult. That's what an emancipation is. Incapacitated, that's not just that well, it depends on the circumstance. The contract could either be void or voidable. You know, obviously, a person with Alzheimer's is not going to be able to list and sell their property, typically speaking, because they lack the capacity to recognize the legal impact of their actions. And so, you know, certainly somebody in a coma, I think it goes without saying that being in a coma would certainly be an incapacity. But, you know, if a person with Alzheimer's or a person in a coma had left a power of attorney, then that person can certainly contract, presuming that they're of age, right? So as long as they've got contractual capacity, then they can sign your listings and close the transaction. Now, not all powers of attorney will work in a scenario like that. So the power of attorney, unless it's durable, unless it is a durable power of attorney, it will not survive the incapacity of the principal. So if I've left a power of attorney with my son and it's a non-durable power of attorney and I become incapacitated, the power of attorney won't work for the contract. Most powers of attorney, we've changed the rules on powers of attorney, and most powers of attorney are now presumed to be durable, And that makes more sense because that's kind of why most people do powers of attorney, so that if something happens to them, then the agent that they've given the authority to can make decisions for them, can sell houses and can buy houses and can make medical decisions and sell cars and things like that. So now a power of attorney will never survive the death of the principal. So when the principal dies, the power of attorney dies. And you'd be surprised at how many people have said, well, I got a power, yeah, dad's dead and I'm trying to sell his house, but I've got a power of attorney for him. Well, the power of attorney does not work after the death of the principal. So you cannot sign contracts after that. Does anybody have any questions on powers of attorney? It's interesting, once in a while, we'll have somebody say, well, yeah, mom's got Alzheimer's and I'm trying to sell her house, but I don't have a power of attorney, but I can get her to sign a power of attorney. Well, what's wrong with that thinking? The power of attorney is a contract. So if you've got Alzheimer's, you can't sign a power of attorney, right? And we are asked this once in a while. Nobody's asked this in a while, but you know, people with Alzheimer's sometimes have periods of lucidity, right? They go in and out of lucidity and they're clearer at some times. So we'll be asked occasionally, well, could you guys kind of visit with mom and see if she's capable of signing your closing documents? Well, no, that's not our job. That's not our jobs, right? Our job is not to wait around until we get a nice clear window and then go in and get the thing closed and then duck back out. No, we're not going to do that. So, but we have been asked that. Anyway, does anybody have any questions on powers of attorney or capacity of minors? I teach a class called Goofy Ways to Screw Up Your Title. And it's just scenarios that I've seen over the years, things that people have done to get themselves in trouble. And one of them is putting your minor kids into title with you. So it's not that minors can't own property. The problem is they can't sell it. They can't contract to list it or to sell it or anything. So don't put your kids in title with you. Even if they're adults, there are lots of good reasons not to do that. So now let me talk about assignments. The general rule for real estate contracts are that real estate contracts are assignable. So you've got a seller and you've got a buyer. And a buyer under a contract actually has a recognized interest in the property called equitable title. And equitable title means a lot of things, right? But one of the things that equitable title means is that it can be marketed. It can be marketed and it can be bought and it can be sold, right? And so that's what an assignment is. An assignment is a buying by one party of the equitable interest of the original buyer. So the general rule for real estate contracts are assignable. And that is one of the major premises of the business of wholesaling. So somebody shouted out, what do I mean by a wholesaler? What do these wholesalers do? Who are they and what do they do? And do you like it? Or how do you feel about it?
They have their benefits in the market. I mean, I think the new company that's out is called Earnest. Earnest does these like flip trainings and things where tell people to get NOD lists, knock on doors, get it under contract, assign it for like $5,000, you know, over for fee in case someone buys it cash, things like that. So I think they have their place, you know, but I just think in this market, any realtor selling house is going to get any more money for that person than any person that tries to sign the contract to an investor. You know, I just think us as realtors shouldn't be assigning any contracts because I don't think we're looking out the best interest of the sellers. Because if we sell in the open market, no matter what condition with times like these, we're going to get our clients more money than assigning it to an investor.
And yet there are dozens, if not hundreds of these transactions that are closing around the state every month. So we have investors, wholesalers, who will bring us 6 or 7 orders at a time. And $5,000 for the assignment fee is actually on the low end. We've seen them go up into the $70,000 and $80,000 ranges. So it can be quite lucrative.
Yeah, and none of these people are licensed realtors,
No.
so they can put those margins in there for $60,000, $80,000. Because us as licensed realtors, we can't do it because we have responsibility to those sellers to give them comparables and things like that, you know?
Yeah, and the people that these wholesalers are working with are not necessarily people who are looking for a lot of money out of the house. Rather, they're looking to get rid of it with no need for cash, no need for an appraisal or an inspection in as-is condition. A parent has died and left a house empty. There's been a bankruptcy, there's been a divorce, there's been an eviction. So that's what these wholesalers use, all of these resources to sort of find these distressed properties, and they're purchased with no questions asked, you know, as is conditions, sometimes within a day or two. So it's the people who are just willing to dump the house, for these low ball offers because they're not necessarily interested in the money. But that's your job as a real estate agent to kind of counteract that and say, well, here are the reasons why you actually want to do a legitimate arm's length sell. And it's usually because you can get more money for them. So these guys are not licensed. They're not always ethical. That's been my experience. Most of them are, but their contracts are assignable because the state forms are not assignable. So, and maybe that's when I talk about the assignment, maybe you're a little confused because you might be thinking, well, this Repc is not assignable. It's not, right? So the Repc changed several years ago because there used to not be a non-assignability clause in it, but now there is. And so there are only 2 conditions under which you can do an assignment. And one is if you're assigning to an entity that you are a principal of. So if I'm a buyer and I've put the property under contract individually, but I decide that I want my LLC to be the buyer. I can transfer or I can assign to my entity as long as I am a principal in that entity. And it could be an LLC or a trust or a partnership or corporation. As long as I am a principal in that entity, I can assign it. And the other thing that makes it assignable is consent, right? So if the seller agrees to the assignment and puts it in writing, then it is assignable. And most people don't realize there is a form for it. It's a UAR form. I want to say 28 or 29. And it's an assignment. There's actually an assignment for new construction and an assignment for existing residential. So it's pretty interesting to look at those and see how those are constructed. So if you do want to assign Repc and you've got a seller that agrees to do it, there are forms that you can use that'll walk you through that assignment. So.
But is it legal that these wholesalers use our addendum and then they send an addendum afterwards that says removing number 19, whatever that assignment clause is on the real estate purchase contract is, you know, that's kind of how they've been doing it. If they use their contract, they just says section whatever 19 of the assignment is deleted or something.
Yeah, and that's legal. There's no because they're not licensed, there are no rules for how they use the state forms. And so anybody is free to use the state's forms. And so you will see in for sell by owner situations where there's no agents involved, sometimes you will see the parties use the state form because it's a pretty good form, and it's got all the stuff in there that you would want in a real estate contract. So you have to use it, right? So the rules are real estate licensees have to use the state forms, but there are no rules for other people using those forms. And as long as, people have signed the addendums, they're binding, whether they're amending the state forms or not. So, and most of these wholesalers have their own contracts. They use their own contract, and it makes it very clear that they are going to assign the contract. So had been working through an interesting problem with an agent working with an investor who has a property that they don't have it under contract yet, but they're going to flip it. So they're going to buy it and they're going to flip it. But prior to them buying it, they're going to go in and do some work on it. They're going to go in and do some rehab work to get it ready to flip. Well, I'm not a big fan of anybody going in and making improvements to a property that they don't own. If something happens, the deal falls through, the seller decides not to sell, the buyer decides that they don't want to buy for whatever reason, right? They get in and they start to rehab it, and the thing is in terrible shape. There's termite damage. It's, probably condemnable. Well, now they've put all their money into this and they want their money back, right? They want to be compensated for the improvements they've made to the property. And then they'll try to lien the property, with a mechanics lien. Well, that's not proper. They're not entitled to a mechanics lien. And unless somebody has authorized you to do the work, and has supervised you doing the work on their property, you might not be entitled to get anything back. So I'm just not a real fan of people going in and making improvements to property until they buy it. But what this guy wants to do is he wants to get it under contract, but he doesn't want to purchase it for 3 or 4 months. And there's an existing debt on it, and he's worried about doing a wrap. If he did a carryback, he's worried about doing a wrap. And so we said, well, then do this, right? Put it under contract, and then do a notice of interest. Do a notice of interest. And I think that a person that has an equitable interest in a property is justified in recording a notice of interest on the property. That would keep the property from being sold to anyone else. And it would also keep the kind of hold the sellers hostage a little bit because that's a cloud or an encumbrance on the title. So that's what he's agreed to do. He's going to go ahead and put it on the contract and then do a notice of interest. And then it's going to go in and do his work. But we've made it pretty clear to him that you could just be donating that money and that effort to this buyer, and you might not ever get any of that back. So anybody have a question about assignments or equitable title? There is another part of your Repc that I think recognizes the character of a equitable title, and it's section 20 of your Repc. So let me ask you a question. If I'm a seller, if I've got a contract, got a seller and I've got a buyer, and there is damage done to the property. There's a fire or a windstorm and part of the roof blows off. Who bears the risk of that loss, and what does it mean to bear the risk? Who has to fix it? In other words,
Seller.
the seller. And you know why the seller has to? Because the Repc says the seller has to. And so under the common law, the risk of loss runs with the equitable interest. So unless the Repc changes that, right, general rule on the risk of loss, then the buyer has to fix the house or buy the house in its condition without fixing it. And so what the Repc says is that the seller bears the risk of loss, and so they have to keep insurance on the property and they have to repair the property. But and this is one of the provisions in the Repc that makes the Repc voidable. The Repc says that if the cost to repair, let's see, I forget the number. So risk of loss, if prior to closing, any part of the property is damaged or destroyed by fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be borne by seller, provided, however, that if the cost of repairing such loss or damage should exceed 10% of the purchase price referenced in section 20, either seller or buyer may elect to cancel the Repc by providing written notice to the other party. So if I've got a $500,000 sale and the damage to the property is going to cost $70,000, then either the buyer or the seller can void the contract and walk away. So, okay, hopefully you'll never have to use that. That'll never be an issue. But when we were doing a lot of short sales, we had some real problems with short sales because, we'd get the short sales approved at a certain purchase, and then the big windstorm had come up and it had ripped the roof off of the property, and now the properties, would not appraise for that approved sales price, and so then you've got to submit a new offer, and go through the hassle of getting it fixed. So it was kind of a bad time, and a lot of these properties were in default, and so the servicers on these mortgages had stopped paying the insurance, right? The insurance premiums. So the insurance had lapsed. So then you'd say, okay, well, let's get this fixed. Who's insuring it? And there wasn't any insurance on it. That is not legally supposed to happen. So under federal rules, a servicer has the obligation of maintaining insurance and paying taxes, even in the event of a default. And that's to protect the collateral of the owner of the loan. And so Has anybody ever had an experience with forced insurance? So if you've got a loan, if you have a loan that, and most loans do, that require not only the payment of principal and interest, but also taxes and insurance, right? It's called PITI, P-I-T-I, principal, interest, taxes and insurance. And then you cancel your insurance policy. Well, what is your lender going to do if you cancel your casualty insurance, your hazard insurance on your house? What will the lender do?
They go get their insurance and they bill you for it.
And it's expensive, right? It's 2 or 3 times what you would normally pay for it, and often it is with a title or a company that they own or that they have a primary interest in. So that's a real conflict of interest. That's prohibited now as well. But they can still force insurance, and they'll bill you for it, and it's very expensive. So, okay, enough on equitable title. Let me talk about conditions, and then we'll get into remedies, and then we'll be done. So, I think most people know what a condition is. A condition, you call it a condition or a contingency, but it's something that has to happen before a performance is due under the Repc. And there are 3 kinds of conditions. There are conditions precedent, concurrent, and subsequent. So things that have to happen before the contract is ripe, things that have to happen at the same time, conditions that have to happen at the same time. And in a real estate contract, those are conditions that happen at the time of closing. And then things that have to happen afterward. So a condition precedent would be appraisal or financing or due diligence or the sale of a property, right? So the buyer has to disclose to the seller, well, I've got a property that I've got to sell before I can buy your property. And that was a really good addition to the Repc, the last change they made to it, because that was happening anyway. And it was always a surprise, all of a sudden buyer shows up and says, sorry, I can't perform tomorrow. I didn't sell my house, so I can't get my loan, right? So now we disclose that and we discuss that. Now that is a condition precedent. A condition concurrent, let me give you an example of a condition concurrent. You tell me what you would do. Let's say that you were representing a buyer and your buyer was all ready to roll. And the day before the closing, the seller says, I'm not going to close. I'm not going to sell to you. I've got a better offer, or I've just decided I don't want to sell. What would you have your buyer do on the day of closing? Anybody? What would you have your buyer do?
Still sign the papers,
Why? That's right, Jill. Why?
because then you would be in breach.
Yep. So if both of you, right? So that is a condition concurrent. Each of your obligations is based on the obligation of the other party. So if the buyer goes in and signs, then he's met his condition, and now the seller has to perform, and vice versa. So if you have your buyer go in and close, then there cannot be an argument of a mutual breach and a cancellation of the contract. And if your buyer wants to sue the seller for damages or for specific performance, they have to show that they performed. Because if you showed up in court and the judge said, well, were you there at the closing? Yeah. Was your money available? Yeah. Then you've got a case. If you say, no, I didn't go, then the judge is going to say, well, then the seller is excused from their performance. And it happens both ways. And it's kind of weird, you know, to have to go into a closing, you know, that's not going to close. It's like a little ghost closing, but just go through the motions, have the paper signed, you know, verify that your loan was ready and the money was available. I'm not saying you actually have to fund it, but you gotta make sure that you meet your conditions. Now, let me talk about conditions subsequent. They're a little different. They show up in different kinds of ways. But let me give you a scenario. So you've got a buyer and a seller, and the buyer says to the seller, "Boy, I hate the color of that one bedroom. It's ugly. It's black. It's black and blue. I hate it. Paint it." And so the seller has agreed in an addendum to paint the room. Right? I will paint the room. Buyer does not do a walkthrough, and they go to close, and it closes and it records. And then the buyer walks into the house, sees the hideous room, and goes to the seller and say, "Hey, you got to paint that room. You agreed to paint it. You've got to paint it." Who's going to win if that goes to litigation? Who's going to win on that one, the buyer or the seller? Anybody got a prediction? Is that who?
I'm seeing seller.
Yeah, my wife is saying the seller wins. She's right. Seller wins. Why does the seller win? Well, because of something called abrogation. Abrogation. Does anybody know what abrogation is? The Repc actually used to have a clause in it called the abrogation clause. So, but what abrogation means is that after you go to closing, the contract's over. The contract is consummated. It's all done. It is all done. And so the Repc is no longer in force, and the obligations of the parties have been met. Right? The parties have agreed that the performances by both sides have been met. So that obligation by the seller to paint the room has been abrogated. Now, what if it's a different scenario? What if you have agreed under the prorations and assessments clause of the Repc, right? Section 4, that the seller will be responsible for the payment of any costs associated with the transfer of the property. So you're out in Daybreak, for instance, where 1/2 of 1% of the sales price of the property goes to the HOA for a community enhancement fee. And that does not get collected for whatever reason, that does not get collected. And so now the buyer takes title of the property, and the HOA comes to the buyer and says, "You got to pay this money." So it could be a community enhancement fee. It could be an assessment, you know, for a condo association or something like that, that had not been paid. So now the HOA comes to the buyer and says, "Pay up." So now the buyer goes to the seller and says, "You agreed, seller, you agreed to be responsible for any assessments or change of ownership costs." Different result or same result as that first hypothetical? Same or different? You stop answering the questions.
Different.
Why is it different? Why do you
Seller
think
agreed to pay.
Well, the seller agreed to paint the room and didn't do it, right?
to pay the HOA.
Yeah, but the difference in those two scenarios is that on this section 4 on prorations and assessments, it's the very last line is a line you've probably looked at many times, but you've never paid any attention to it. It says the provisions of this section 4.3E shall survive closing. Survive closing. So what does it mean when you have a provision in the contract that says it survives the closing, it means it's not abrogated. It is not abrogated. It's a continuing contractual relationship between the buyer and the seller. So if you ever want something to happen after a closing, you put it in an addendum. You make that specifically survive the closing so that it is not abrogated. It's not a bad idea on any addendum just to throw in that line. This addendum survives the closing, or this provision survives the closing. So, okay, one last thing, then I think we're going to be done. We'll wrap it up. I've mentioned this a couple of times. What does specific performance mean? Well, in a real estate transaction, it means that the buyer can force the seller to perform. So if a seller has said that I'm not going to close, the buyer can sue the seller and make the seller close. And a lot of lawyers and a lot of people think that's not true. But we've been involved in a couple of lawsuits where the courts have ordered sellers to sell the property. They will not, however, order a buyer to buy. And so a seller's remedy is cash or the earnest money, right? You either take the earnest money or you don't take the earnest money and you sue for damages. But they will not make a buyer buy, but they will make a seller sell. And if the seller still won't sell, then there's ways of making a seller perform or appointing somebody to perform on behalf of the seller. So we had a really interesting experience with a guy who bought a condo in Davis County and the seller wouldn't sell, and she turned out to be a little nuts. And he finally forced her to sell, and there were dead cats in the house and a big bottle of poop, and she'd been using a big water bottle for a toilet, and it's a great story. So, but he forced her to sell. So I got another letter. Everybody see it? Okay, we're done. Thanks, guys.
Hey, thanks, everybody. I'm going to go ahead and put my email address in the chat again. And so if you will just email me your name, your license number, and the letters, then I will get it banked for you. So let's see, here we go. Where's my chat button? There it is. All right. Everybody get that? Good. Well, have a good day, everybody.
Thank you.
Okay.
Ew.
Okay. Bye-bye.
Bye.